Thank you, Eva, for the introduction. Hello, everyone. Well, today I will talk. I'm actually glad that I have the opportunity to showcase my approach to this topic. Not only because generally I'm passionate about situations where maritime law meets criminal law, but also as well because it's really a trendy topic in our country, Croatia, because in recent history we've had multiple cases and situations in which Croatian shipmasters were proclaimed guilty of the crime of unauthorized production and trafficking of drugs, basically purely because of their function on the ship. So today I'll show you my approach and how I see this topic and what my takeaways and conclusions are. I was thinking how to start this presentation, and I chose to start with one basic principle of criminal law, which says that nobody can be charged with or accused of a crime or punished by a sentence that was not previously determined as such by the law. This is a principle of most modern constitutions around the world, and it can serve us as a good legal basis to talk further and to extend more this topic. Basically, what we need to know is that in criminal law, everything must be prescribed by the law specifically. So, when we talk about this Latin saying, for example, it is obvious that we need to understand what is a crime. We cannot punish or sentence someone for a crime if we don't know what is the crime and what elements create a crime. So in this slide, I would like to show 5 most important elements of a crime that we need to determine in each case in order to actually condemn or punish someone. Of course, that we need to have a concrete subject, someone that actually conducts an action that will constitute a crime. That subject, as I said, must do something, must make some action, but we also must not forget that crime can be committed by action, but as well by omission, which will be very important for this issue specifically. In criminal law, such action or omission cannot be any action or omission. We must determine that action that we are talking about, specific action, must correspond with description of a concrete crime that is prescribed as such by the law. Only then we can talk about possible crime. So we must have action that actually corresponds with description of any crime that is enumerated in criminal code. After that, we must determine 4th element, which is a guilt. And of course, if we have 4 of these, we can actually punish or sentence someone. When we talk about guilt, I will just briefly go through 4 typical basic degrees or types of guilt. Of course, we have intention. Intention is most simple one, we can say, because when someone conducts a crime with a direct intention, that means that that person wanted a crime, wanted to conduct it, was aware of it, and wanted to provoke the consequence of a crime to happen. When we have indirect intention, that person was aware that the consequence of a crime can happen, and he accepted it. And the 3rd and 4th degree of guilt are specific. First of all, because crime cannot be conducted in Croatia with conscious negligence or unconscious negligence if it is not specifically and expressly prescribed as such by the law. So only crimes that are specifically prescribed in the law that can be conducted by negligence can actually represent a crime done by negligence. Okay, after talking about guilt, last introductory part would be to present action and omission in the context of this topic. When we talk about action, I don't think we need to talk much, especially because in this concrete shipmaster situation, action was never an issue. Of course, if we have a shipmaster that acted, made positive actions, was part of some criminal association or larger, wider criminal plan, of course that shipmaster will be sentenced for illicit traffic of drugs. What we need to talk about is omission, because that's where the issue starts. So, in order to understand the institute of omission, and when we can conduct a crime by omitting, not by acting, we need to understand firstly that there are two typical major differentiation categories of omission. We have true omission crime. That is a crime that can only be done by omission, and it is prescribed as such by the law. For example, not providing a help to someone. That is a crime that can only be conducted by omission, which of course will not be the situation in this concrete topic and issue that I'm talking about, which we will see later. Second category is quasi-omission crimes. We need to differ legally regulated and legally not regulated. Legally regulated quasi-omission crimes are those that can be conducted both with action and omission. And law always prescribes both possibilities. Legally not regulated is most interesting category, because those crimes, for them, the law says that they can only be conducted by acting, not by omission. But they still can be conducted by omission. So now we need to understand how is that possible. That is possible only in two scenarios. If we have the person that we can call guarantor, and when we have a person on whom command responsibility can apply. So we need to understand the institute of guarantor and command responsibility. Guarantor is a person that has legal duty to prevent the occurrence of the consequence of a crime. That person is specifically, directly, and concretely obliged to prevent the consequence of happen. Everything is more simple through the example. For example, if you talk about the murder, this is a legal description of the criminal deed murder that says whoever kills another person shall be punished. As we can see, this criminal deed can only be conducted by action. But if we have guarantor, for example, we can make an example of parent and a child. Parent is obliged by the law specifically to take care of child, to keep it healthy and alive. So if we have a parent that purposely does not feed his child, omitting, and that child dies, that parent will also be condemned and sentenced for murder, no matter that the law description of this criminal deed says or has a presumption that this criminal deed can only be conducted by action. So if we have guarantor, even this kind of criminal deeds can be conducted by omission. Command responsibility is special manifestation of guarantor concept, with the difference being is actually very similar to guarantor, because command responsibility also lays on a foundation that someone has duty to prevent something. But with command responsibility, we are talking about being responsible for someone else's action, to prevent someone else to cause the consequence of crime to arise. I'll explain this on next slide. So after this introduction that I made, I would like to apply all of this to concrete situation. When we talk about illicit traffic of drugs and criminalization of shipmasters, in Croatian Criminal Code, that criminal deed is in Article 190, and it says, who produces, processes, transfers, exports, or imports, acquires, or possesses substances from paragraph 1 of this article, which are intended for unauthorized sale or placement in any other way into the market, or offers them for sale without authorization, will be punished. Let's analyze this criminal deed. Can that criminal deed be conducted by action? Of course. Actually, as I said before, this criminal deed would go into that category that in accordance with the law, it can only be conducted by action. So we can do it by, of course, acting, doing something. In order to understand, can we omit and conduct that criminal deed, we need to answer a few questions. Is this a true omission offense? No, it's not. Because true omission offenses, as I said, can only be conducted by omission, which is not the case here. So the answer is no. Is this quasi-omission offense? Is it legally regulated quasi-omission offense? It's not. Because legally regulated can be conducted by omission and action, but both of them must be directly described as such in the law. As we saw before, this criminal deed says the one who exports, who imports. We do not see omission in legal description of this crime. That's why this criminal deed does not belong to legally regulated quasi-omission offenses. Actually, it belongs to legally not regulated quasi-omission offenses, because, as I said, in this description, we only have active action, positive deeds. So in order to condemn someone for omission for this criminal deed, we need to see if the subject is whether guarantor, which is, okay, I will say first, whether if it is guarantor or if the subject has criminal command responsibility. When we think if shipmaster can be guarantor, the answer to that would be no. Why? Because when we talk about guarantors, like everything else in criminal law, it must be specific and concrete. Like I said, parent has express obligation to take care of health and life, of course, of his child, which is expressly enumerated in multiple laws, family law and other laws. Shipmaster does not have legal duty to prevent export, import of illegal substances. Concretely, that is not prescribed anywhere. That's why he's not guarantor. One more reason why he's not guarantor. With Croatian shipmasters that were punished or sentenced, they were never punished or sentenced on the basis of being guarantors. So that's one more proof. If that is a possibility, maybe it would be even better than command responsibility with what they are doing, which I will tell later. So guarantor is not an issue. It never happened in practice, as far as I know. Bigger problem is command responsibility. And we also need to think and process, can we apply command responsibility to shipmasters? Well, as you can already see from this symbol, that my personal opinion is that we cannot apply command responsibility to shipmasters. First bullet point is actually why courts have been doing it in the past. Most maritime codes have similar provision to this, which shortly says that shipmaster is responsible for everything. Those courts, some courts created practice that this means that whatever happens on the ship, it's shipmaster's fault. Even if we are talking about crime and criminal liability, same. Automatically, command responsibility, you're guilty. That is what is happening in practice. That is huge infringement of basic principles of criminal law. As I said before, nullum crimen nulla pena sine lege. Command responsibility must be specifically prescribed by the law in order to apply to someone. Also, criminal law is characterized by prohibition of analogy. We cannot do analogy in criminal law. We cannot say we have military commander, it's similar to shipmaster, he's responsible for everything. Command responsibility applies to military commanders, and let's apply it to shipmasters. That's forbidden in criminal law. We cannot do that. It must be specifically prescribed for both. If it's prescribed for one, we can only apply it for one. But the best proof to that is, it is true that military commanders undergo command responsibility, but they do undergo it because it's specifically prescribed by the law in Rome Statute and in Croatian Criminal Code. That's why we can apply it to them. For shipmasters, we don't have this. So that's the reason why we cannot do it. Yes. So I reply to the question. My opinion is that we cannot apply command responsibility to shipmasters. But I went even further in defending this thesis. I assumed that it exists. Let's say that we can apply command responsibility to shipmasters. For sure, we cannot do it like it is happening in real life with our shipmasters. Nothing happens automatically. Even if we can apply command responsibility, it does not mean something happened, command responsibility, you are liable automatically, prison, or we cannot do that. Command responsibility is actually a very deep concept. We have five elements that we need to prove in procedures to apply command responsibility, and it's extremely complicated. First thing that we need to prove is factual authority. We need to prove, we are not talking about formal or symbolistic authority, we are talking about factual authority. We need to prove that, for example, shipmaster, if we are going to do analogy, which is forbidden, but if we are going to do it, then we should do it properly. We should prove that shipmaster had actual power to direct actions of his subordinates. In that moment, in those circumstances, that he could have done something about it. So we need to prove that it exists the ability to dispose effective means of command. Factual authority, effective means of command. That's the first thing we need to prove, which is already not that easy. Second thing we need to prove is awareness of the guarantor duty. We need to prove that shipmaster is aware, under given circumstances, that he is guarantor. As I said, mom is guarantor for child's life. Military commander is guarantor of fundamental rights of the enemy state, its armed forces and civilians. So we would need to prove that the shipmaster is aware of that guarantor duty. That would not be that difficult, because of course, if he's a shipmaster and he went through education and experienced everything, of course he will be aware that he has guarantor duty, unless some extreme circumstances arose on the ship. Third thing we need to prove is failure in duty to prevent or failure in duty to punish or repress. So we need to prove in concrete situations that shipmaster failed to prevent the consequence of a crime to arise. Or if the crime already happened, that he failed to punish people that did it. But why is this difficult to prove? Because knew or could have known. This is two additional elements that we must prove. We must prove that shipmaster knew that something is going on, or that he could have known. So even if he failed in his duty to prevent, but these two additional elements are not proved, we still cannot punish or sentence the shipmaster for a command responsibility. We also need to prove that concrete consequence of a criminal offense happened on ship. Only if we prove all of those, we can say that omission is equal to action, and that omission action means criminal liability. In these two slides, I wanted to show that even if we apply command liability, which we are not allowed to, this is what we need to do. All of these 5 elements we must prove to punish shipmaster or anyone else who undergoes criminal liability. We cannot do it automatically. Command liability, you are liable. We cannot do that. I assumed even further. Let's say that we apply command liability, which we cannot do. Let's say that we proved 4 out of 5 elements, which is also impossible. Let's say that the only thing we need to do is to prove the guilt, or that he knew or could have known that there is drug on the ship. Even if we assume all of those, we have 3 layers of assumptions, wrongful assumptions already. But even then, we must say that transfer of cargo is documentation procedure. Shipmaster is not even allowed to go inside the container. That's not what he's doing, what he's obliged to do on the ship, and check what is inside. What shipmaster and his crew must do, they need to maintain the cargo in accordance with the shipper instructions. And of course, the most important thing is to actually deliver the containers that we're transferring through the vessel. So in this 4th layer of assumptions, we could see that it would be really difficult to prove that he knew or could have known. Just because it's documentation procedure, and here really does not see the inside of container. Last assumption, 5th one, let's assume that he is obliged to check inside. Even if he is obliged to check inside the container and the drug is in the container, still we cannot punish him automatically. We will still need to prove that he should have known that drug is inside, because in real life situation, he can check the container, he can do everything that he's supposed to do, but some concrete specific circumstances on the ship happen. We will still need to prove it. It would not still be automatic. We will still need to go prove, deliver evidence that he, under those circumstances, knew or could have known that there is drug on the ship. Okay, this is last slide. This is conclusion slide, in which I will put long story to short story. As I said, the concrete criminal deed we are talking about is unauthorized production and trafficking of drugs. Can we do that crime by action? Yes. Can we do it by omission? Can shipmaster do that criminal deed by omitting? No. because he is neither guarantor or command responsibility can apply to him. Even if we apply command responsibility, we cannot do it automatically. We need to prove 5 elements. Even if 4 out of 5 elements are satisfied, remember it's a documentation procedure. 5th element, guilt, his knowledge, would be very difficult to prove. Even if it would not be a documentation procedure, would we have 5 out of 5 elements? We don't know. Still thing to prove in the court with evidence. So when I was thinking, what is happening? Why is this happening? How to justify applying command liability first, which is not prescribed anywhere? How to justify it when you are doing it, interpreting it in a way that it means automatic liability? I really would not know how to justify that legally. That's why this will be my last sentence of presentation. This is a quote from port's captain in Greece when Captain Laptalov, lawyer, asked him, why is this happening? This was a reply from port captain. You cannot sit now.
Here, the green one. Ante, click this.
Where?
Is that
The green,
censorship?
the green one.
It's okay. I carry it for you. This is not destined to see. Okay, this is what he said. Port captain said, I have 52 kilos of drugs and I have to arrest somebody. So you decide if this is adequate legal basis to punish shipmaster. Thank you.